There's an overlay of someone called Mr. Jose Camargo. What we were trying to show the court that this is an overlay document. And we wanted to actually show the court where this document from Jose Camargo has come from. The document relating to Jose Camargo has come from the QR register, which is distributed to every polling station. And that document is even in the possession of this court. If you look at the scrutiny report, the QR documents are there. So what happened? Apio took an original Form 34A, he had the QR register, and he took a picture of it. What is the evidence that is being given in this court? That someone called Jose Camargo is interfering with this. And the point we want to make to this court is that if you look at the scrutiny report and if you look at the QR register, which is in those boxes, you will actually find the name of Jose Camargo on the register that has been printed. We've also produced the original Form 34A. We've come with the receipt. And we're being told that you cannot produce your original 34A, that Jose Camargo was interfering. And in fact, if you look at the numbers on the original 34A, it's the same as what the picture of the overlay was taken. So to the question that someone called Jose Camargo was interfering with the portal, it's actually not true. It's incorrect. And the attempt to prevent that evidence to the court is should actually guide the court that actually that is not true. Why will anyone try to interfere with a portal transmitting, and the result he has is the same as what is in the A and what is in the portal? So to that question, we submit that that is not true, and that is an overlay that someone who has taken the picture. We will give the court the Form 34A to compare with the original 34A with the certified copy that the court has. And in fact, we direct the court to the scrutiny documents. That register of opening and closing the KIM is there, and the name of Jose Camargo for purposes of audit trail is printed in there. Smartmatic Jose Camargo is printed there. So what has happened? Someone, Apio, took a picture on that one. The next point I want to make is the issue of the KIMs. We've been told there are two KIMs kit which had the same serial number. And we understood our role to this court to give all the information to the court to make a decision. We admit that those KIMs have the same serial number. It was an error that originated at the time of the serialization. But we want to tell the court that those KIMs have different IMEI. They have different IP addresses. They have different polling stations. They have so they have different identifiers. And we acknowledge that that is an error that originated relating to those two KIMs. But there are other identifiers that can identify those KIMs are from our system. And we want to give that information to the court for purposes. Those KIMs are on their way to this court. We will give to the registrar of the court for the court to analyze and to look at it. And if you look at those KIMs, they transmitted the forms as required in the portal, and the A's also are coming, the original A's we will also give for those three forms. And our role is to give. The issue of transmission has come up. I just want to say this. There were three sets of transmissions at Bomas. One on the forms that has been downloaded, that was running properly. The second one related to the constituencies, that was continuing. The one which had stopped was the one on the tally. And the reason it stopped was, for 3 days, we had only verified 50 arrows. The process became clogged. For you to be able to transmit to the announcement, verification had to happen, then announcement happens. That means that those arrows have to be stopped because verification cannot happen as announcement is happening. We will be running numbers that have not been announced yet. So because of that, and because of the audit, forensic audit that most of the agents were recommending, we had to stop that process to give verification a chance. There was nothing malicious about that. For those few remarks, Your Ladyship, I stand guided. Thank you.
Mr. Mahat, maybe we can have a look at the
My lady,
original
if the
34 that you are showing.
sorry, my lady, Chief Justice, if the form can be handed over to the court. Excuse me. A moment. Thank you. My lady, my learned friend, Senior Counsel Mulgore, has a comment after the court has seen the...
As you continue to look, we'd just like to make an observation. In fact, we are happy that the court receives the document, particularly the Form 34A, and everyone has been quoting Shakespeare and all the rest. I'll just quote some Swahili. Siku ya nyani kufa, miti yote huteleza. If you notice on the 34A, the UDA agent, the second agent, signed the form on the 7th of August, 2022, before the election. Before the election. I repeat, before the election. The other one as well, perhaps might have signed it on the 7th, but it's not clear. So that's all we wish to say.
While at it, Counsel, just before you go back, and when did the other agent sign?
It looks like 7th, it looks like 9th. Only the Iebc and Mr. Chebukati can tell us. It is there.
Yeah, before they explain, they would have to have something to explain.
We have let it go in.
This form, from the naked eye, of course, appears to have been signed by both agents on the same date. And the same date is 07.
Oh, 07 of 08.
07 of 08.
Yes, indeed.
See, well, I thought the point you were making was that the second one signed before the election. As though the first one, if I could just finish.
Okay.
As though the first one had signed on a different date.
No, our point is, and has always been, these forms may have been manufactured elsewhere, before, well after voting, and they all arise one day and they are counted. It is the mess that is IBC, and it is the mess that is the 2022 presidential election that we have been emphasizing. Thank you.
You still want to talk?
Madam Chief Justice, my client is the one who is likely to suffer most in case these sensational matters are not dealt with effectively. Starting with the date, that is more of drama than reality, is seeing a speck in the other person's eye when the log is in the other person's eye. One of the things I think I ought to place on record is this. The forms that are now in issue have not been pleaded, were not tendered, and since they were not pleaded and they were not tendered, we should not be accused of not having responded to them. Point number two, both agents have made a legitimate or have made an innocent mistake about the date. And I don't see where the laughter is emanating from. Point number three, the form itself shows a contrary position to that which was sensationally displayed before this court. The sensational reporting that was made was intended to convey a picture which is to the opposite of what the form now before the court conveys. And that reminds me of that very unfortunate day in 2017 at 9 p.m. that again sensational claims were made about forms 34B from Mombasa, in particular Shangamwe, made also to this court and which led to a nullification of a presidential contest. Madam CJ, there is also one more thing that concerns my client. because again, it has very prejudicial effect. It is what is definition of the commission. I will spend 1 or 2 minutes defining the various ways commission is defined in the law. Commission is first and foremost defined in Article 88. Commission is also defined.
Sorry, if we open the matter now to other things, we will not see an end to this. You were responding to the 2 forms which were introduced.
As new evidence.
Yes, please don't go to other things that you are not supposed to, because we will not see an end to this.
I still have my time.
With respect, even if you have your time.
For the governor,
even if you have your time.
Thank you.
Just deal with the 2 forms.
So then, coming back to the forms, my request is this. Please delete from the... yes, the other thing is that all the form now before you has security features. The one that was displayed does not have. The one that you have does not have the name of Jose Camargo. The one that was displayed before the court has that name of Jose Camargo. The original one you now have does not have that name. And all those things were meant to deceive. They were meant to mislead.
We should never have to ask that we remain the way we started. We should never have to ask that.
Particularly from such eminent lawyers. The one that you have does not have any of those things that were displayed. My client therefore becomes quite concerned whether this case is to be adjudicated in the realm of falsehoods or within the parameters of factual contestations. That is a real concern. The minute we allow matters which are clearly false to infiltrate into the record of this court, we are likely to get into a very, very unfair decision. Let this case be decided on factual points and on factual contestations. We say the same about the second form, that the original has not been provided. But as regards the second one, allow me to say this. Before this contest started, Iebc did avail to this honorable court all the forms 34As. All of them were deposited because we did see that correspondence. Consequently, as regards the second form, I would request this honorable court to find time to look for it, the certified copy, and in case, once again, it does not have this JOS, whatever name it is, please come to this conclusion, that a deliberate effort was made by counsel to mislead this court so as to arrive at a decision which would be most injurious to the first and second respondents. I'm very grateful for the 5 minutes, and I rest.